Hi once again. Thanks a lot for tuning in to the Midwest Law Enforcement Training Institute. I'm Joe Wells. Like I said, thank you very much for checking things out here. I feel like I'm sort of convening a weekly meeting for law enforcement training. So some points of interest before we get started with this week's topic. First of all, I'd like to say thank you very much. I've watched our numbers grow both on YouTube and Facebook for the past couple of weeks. I really appreciate the participation. Just for basic interest's sake, the numbers we've got aren't huge, but they've been growing consistently. Also, I know they're pretty organic because I haven't paid for ads. I haven't done any type of those online tricks. It's all been through people sharing the videos and people checking out the posts we make on a daily basis. So, once again, thank you very much for checking the page out and for watching the videos. If you can, I'd like to solicit some more help as we continue to move on and move forward. If you can, share these videos with your friends, post them on your own wall. Try to interest some more law enforcement personnel from around the state of Indiana to get involved. I'd like to see the community keep growing. So appreciate it very much. Thank you once again for that help. Second of all, we're going to look at a couple more topics coming up here. It's coming up, we go to SFST instructor research in a couple weeks, so we'll be bringing that information back to share with you then. Besides that, my specialties are domestic violence, SFSTs, and report writing. So if there's some of those three topics you'd like to have covered for one of these shorts, please let me know about it and we'll get it covered as we go along. Or any topic in general. As a general instructor, we can pull information off the web or share local updates and so forth too. So that's some of the stuff I like to do here on the training page. So if you've got some interest, please let me know about it and be sure to participate a bit more on the page. And we'll try to get some more things going back and forth here as the year continues. Now, today's training update is pretty much about a local court, well, not a local court case, about a national court case that's got a lot of attention locally. If you've heard the big case out of Pinehurst, North Carolina, concerns taser usage, and some of the court's opinions have limited what we can do now with tasers. I'd like to review that case, because we've got a lot of negative kickback the first couple weeks. The decision was made on the 11th, and right away it was almost a big fear factor going throughout the country of, oh no, we can't use tasers anymore, we have to change all of our policies, and we might have to take tasers away. I've heard a lot of discussion. We've been talking about this constantly for the past couple weeks online on different discussion groups and different forum boards, and it's not that bad. Yes, there are some opinions of the court that will impact how we can use tasers, but it's not the first time this has been done. I'll touch more on that later on, but there were similar cases in 2011 and 2014 both. So it's nothing to get panicky about this time, but it's just something to pay attention to and see that some more standards have been set through legal precedents. So if we can, like to sort of pay attention here for a bit, we'll review the case with you and talk about some of the important factors that some of the important decisions the judges made and share some of their opinions and see if we can go from there and get some maybe some results and sort of calm some people down. One of the worst things I hate about this stuff is when people get panicky and there's a bunch of knee-jerk decisions going very quickly about changing policy and procedure when we've got a bit of a decision made, some precedent set, but if we sort of let cooler heads prevail, we'll see that it won't impact our law enforcement actions that much. So I'll just go ahead and get started here. The case, once again, as I said, is Armstrong versus Pinehurst, North Carolina. This came from the 4th District U.S. Court of Appeals, and it does limit some taser use in their opinion. So this case comes from April 23rd, 2011. Ronald Armstrong is a bipolar schizophrenic, and when this scenario started, he had not taken his medication for 5 days. Now, during this time when he was off his medication, he began injuring himself. He was actually using a sharp object to poke holes in his leg to let the air out. It was his reasoning for doing that. Now, his sister got concerned and was worried for his safety. She actually convinced him to go to the hospital and get checked out. I think she used a ruse about the holes in his leg needed medical attention. So she got him to go to the hospital. While they're at the hospital, he figured out there's a psychological evaluation going on and didn't want to stick around for that. So he decided to leave. He left during the exam. Now, the hospital had already started what we call here in Indiana an EDO, or emergency detention order. So he's going to be held against his will for psychological care and to make sure he was safe and get back adjusted on his medication. So that process had already started when he left the hospital. When he left, the hospital contacted local police. Police arrived on scene. At that time, the EDO was not complete or ready to be implemented. So the officers sort of implemented a ruse of themselves, of their own, and they went out and they actually contacted Armstrong in more of a consensual contact, more of a consensual encounter. He started to walk into the road. They stopped him by talking to him and asked him to come back to the sidewalk and just engage in casual conversation until the EDO was signed. Once the EDO was in place, they told Armstrong about that and said pretty much you have to come back in the hospital for care, and he did not want to go. Now at this time there are 3 Pinehurst police officers. There are also a couple security officers from the hospital. They're on the hospital property, pretty much on a roadway adjacent to the hospital. And that's a scenario. So you got 5 law enforcement and security personnel total involved, plus his sister was on scene. Now, they tell him that he's being held under the EDO and he has to go back in the hospital. He does not want to go. How does he resist at this point? He flops on the ground and wraps his arms and legs around a pole. It's essentially a sign pole that's in the easement next to the hospital. So he locked himself down pretty solidly and anchors himself to the ground. Now, once he's on the ground, this is where some of the contention comes into play for the legal aspect of this case. The officers begin to grapple with him, but pretty quickly, the supervising officer tells another officer to ready a taser. That's done, and within the first 30 seconds of him flopping on the ground and grabbing this pole, the taser is deployed in a drive-stun fashion. Now, of course, a drive-stun is not using the prongs, it's using physical contact, and it doesn't disable a person, it causes pain, and you're hoping for pain compliance at this point. Due to Armstrong's diminished capacity, when he was tased under the drive-stun fashion, the pain did not cause him to give up. As a matter of fact, it caused him to resist even more. The officer repeatedly applied the drive stun. It was 5 times within pretty quick succession. And eventually, when he fought more and more, the officers on scene just resorted to good old physical use and peeled him off the pine pole, handcuffed him, and in the process of putting him on the ground, face down on the ground, he began kicking at the officers. So the officers also shackled his ankles. Not a hogtie fashion. He was handcuffed behind his back, and he was also shackled. So he was secured on the ground. They place him down, and the officers, of course, try to regroup and compose themselves. There's always some downtime after a situation like that. And while he's on the ground, Armstrong's sisters noticed that he appeared to be in medical distress. Now, the officers looked into it right away. They realized that he was in distress. As a matter of fact, he was unresponsive. So right away, they removed the handcuffs and the shackles, and they started CPR and called an ambulance. Now, this is one of the points of contention for the legal system as well, because from the point of the EDO being signed and put into effect, and the officers confronting Armstrong about the EDO, to the point the ambulance was called, was a grand total of 6 minutes. So it was a pretty quick escalation of the situation, and it went pretty bad pretty quickly. So that's one of the points we'll discuss later on with the court's opinion. Now, he was transported back to the ER where he later died. So that's the point we have right here. We have a person who was mentally incapacitated, trying to be taken into custody by police officers. There was some contention about the use of the taser not causing the death. He did struggle with 5 police officers, or 3 officers and 2 security guards. So he struggled with 5 people, so he was under physical exertion as well. During the act of handcuffing, it was a standard. They got him on the ground, put knees in his back, and put pressure on him to hold him down while he cuffed him and secured him. So some typical actions among police officers right there. Of course, when he passed away, his estate, run by his sister, sued the police department, as well as Taser International and everybody involved. There's a typical et al. Lawsuit. Now, the lower courts found in favor of the officers. So that's one of the good things. Basically, it's qualified immunity, which comes into play when officers are acting under what they believe is the guise of the law, and they operate and act under what they believe is correct. So they were given qualified immunity, and right away it was appealed. The appeal was heard in the end of last year in 2015. The decision is handed down here on January 11, 2016. Now, this is where a lot of the concern comes when you look at the appellate court decision. First of all, the appellate court agreed with the lower courts in granting qualified immunity, so the liability factor was not answered right. There was not changed. The officer is still pretty much in the clear due to qualified immunity. However, the appellate court found that the officers used unconstitutionally excessive force while arresting Armstrong. This is where a lot of different opinions come in. Some of the opinions written, first of all, concerning the mental illness. One of the judges was concerned and said if the officers are aware of the condition, they should know that the person may have a diminished capacity to respond to basic comments and orders. When this first started out, the officers gave Armstrong verbal commands that he was being detained and so forth, and he did not react as most people would. Right away, they think some of the reaction of him dropping on the ground and grabbing the post was due to his diminished capacity of the schizophrenia and bipolar situation. So right away, the court thought that if a person's mentally ill and the officers knew that, they should know that the reaction will not be what we call normal. Also, that they know that in this situation, with a person diminished mental capacity, that force may exasperate the situation or make it worse. One opinion of the court was that the police thought the court believed that the police should have specially trained people available to make more of a counseling situation instead of a use of force situation. So we're talking about some resources that should be available right there according to the court's opinion. Now, also in the court's opinion, they mentioned how the doctor determined that Armstrong was a danger to himself and not others. And that factor alone, he was a hazard to himself, not others or anyone else in the doctor's opinion, should make a difference in how much force we put into use while effecting an arrest or detention. Where the seizure's sole justification is to prevent harm of the subject to the seizure, the government has little interest in using force to effect that seizure. So basically, if a person is just a hazard to themselves, it's less of a priority to use force if a person is a hazard to other people. Okay, that's opinion of the court right there. Just something to let sink in for a second there. Also, they mentioned that Armstrong's resistance was essentially a static impasse. He flopped on the ground, grabbed a post. He was not attacking anyone. He was not attacking officers. He was not attacking passersby, nothing like that. He was locked on to a post using his arms and legs. And so the timing effect comes into play once again. The court thought that the use of force was very quick and very decisive, very polarizing. They thought that maybe some more time could have been spent and maybe some more resources could have been used besides just going directly to the taser and physical force right off the bat. So that was one opinion right there of the court. Now, the court's opinion, immediately tasing a non-criminal mentally ill individual is not a proportional response. And we talk a lot about Graham and O'Connor and so forth. You look at the use of force if it is not shocking to an individual as far as what type of force is used. It doesn't shock the senses. Not a play on word for the taser either. I'm talking about legal standards about use of force not being shocking or alarming to a basic individual. It also has to be a use of force appropriate for the direct opposite use of force. In this case, Armstrong was just locked onto a post. He was not attacking anyone, so they thought the use of the taser was a little extreme at that point to cause pain. Because deploying a taser is a serious use of force, according to the court's opinion, as a weapon is designed to cause excruciating pain. The court also cited the training by Perf, Cops International, and Taser International, that actually mentions that a person's diminished mental capacity may not get the desired effect with a drive-stun pain compliance technique. And finally, a couple of court decisions. First of all, in the opinion, physical resistance is not synonymous with risk of immediate danger. So basically, someone being passively resistant, such as sitting down and grabbing a pole or just sitting down and refusing to move, is different than somebody who is physically attacking an officer or somebody who is physically putting someone else at risk. So we have a difference of opinion right there, a difference of use of force options, and that's something officers should be aware of. Officers must be able to articulate how the use of force is justifiable to prevent harm from themselves or the public. Remember also, we already said that if a person's going to harm themselves only, the priority isn't as much as if they're going to harm an officer or the general public. So you have to be able to articulate how your use of force is preventing injury or protecting the safety of another or yourself. In the court's opinion, which seems sort of contradictory right here from what we've already seen, this is a quote from the court case: "We certainly do not suggest that the appellees had a constitutional duty to stand idly by and hope that Armstrong would change his mind and return to the hospital on his own accord. But the facts of this case make it clear that our ruling does not hamper police officers from doing their jobs." Now, the decision right there, which is pretty much critiquing how officers use a taser and when it's actually appropriate to use, and not being hampered to our job, is sort of a difference of opinion for a lot of different people. Pretty much what we're looking at is more of a restriction on taser use. So it'll be more hand-to-hand contact with people, and just the taser is taken out of the game plan for a lot of different things so far with this decision. Also, in the court's opinion, one of the reasons they decided this way is that tasing Armstrong did not force him to succumb to the seizure or give up, basically, and comply. As a matter of fact, the pain actually made him fight more, which is the difference we saw earlier. They believe if the officers on scene would have gone a different route and not so quickly gone to the use of force, they would have had a wider spectrum of tools to use and more things available to them in the long run, such as maybe waiting, debating maybe a bit more, going directly to physical contact, which could have resolved the situation differently. Once again, a couple points of interest. Did the taser kill Armstrong? No, of course not. The overall situation did, his physical situation, the fact he did have officers on his back and holding him down during this whole confrontation made a big difference as well. So it wasn't the taser that killed him, and we're looking at a situation, just the court's overall opinion of the use of taser is something to watch out for now. So my basic opinion, yes, I'm concerned about a couple of things. I've used my taser several times in my career. I'm actually a bigger guy. I'm 6'5" and 300 pounds. The taser is great for me because if I go physical contact with somebody, the chance of causing an injury is pretty good. If I throw a punch at somebody, 6'5", 300 pounds, it's going to have an impact. It can damage their body. It can cause a severe injury. The taser, in my experience, has been a pretty safe alternative because I can deploy the taser, disable a person before I have to go hands-on. So that's always been my sort of commercial for using a taser or using other devices like that, going quickly to a different tool instead of going to physical force. A couple ideas and opinions. I'd like to see what some other opinions are at your point. Please do me a favor and participate in the conversation below in the comments. But right now, these decisions, first of all, one thing to remind yourselves of as well, this is not the first time for a decision like this. I believe the 9th District Court had a similar decision back in 2011, and the 7th District Court had a similar case in 2014. So this is not the first time. However, it's showing the momentum of the courts going away from law enforcement a bit and being a little more restrictive on the tools we have available to us, and asking officers, basically, or making officers be a little more responsible in the use of the force they use for different types of tools like the taser. So right now, I don't think any huge changes should be made. Right now, one of the things that concerns me the most is worrying about the departments having knee-jerk reactions and taking the tasers away from officers, or having a total knee-jerk reaction and telling the officer it has to be very restrictive. We saw in Chicago with the Laquan McDonald case, where tasers weren't available to everybody on the force. It's just a specialty tool used by a supervisor. And we see when it's not available on the scene, things escalate beyond the taser because that taser is an integral part of the puzzle that can possibly help stop these cases before they get too far ahead. So I think it's a very tricky, slippery slope to walk on right now. But first of all, I'd like to basically remind people to go back to your taser training. The initial training by Taser International mentioned a lot of these things along the way. So just maybe go back to taser training. And this will restrict taser use some. Basically, if a person is fleeing, we've seen a lot of those pursuits already where a foot pursuit starts and the taser is used to stop the person from running. By this opinion, it's not really a justified use of the taser anymore. If someone is in a situation where they're trying to harm themselves, a use of a taser is not automatically available. If you can possibly articulate how maybe if someone's committing suicide with a knife in their hand and it's safer for you to shoot the taser from 12 feet away, that might be a point to articulate in a report or a situation you have to wait for. Where if a person is just ready to harm themselves and not be an immediate threat to somebody else, the taser might not be justified by this opinion. I'm hoping that some big departments with some resources to do some studies and research will sort of chime in and help diffuse some of the situation. Maybe some private companies like the Force Science Institute will chime in and help diffuse the situation a bit. But until then, I just say follow your training. Be cognizant of what the current opinion is of the courts and the current attitude amongst the law enforcement system and the legal system when you're using your taser and you're getting a force situation. So, all right, hopefully that cleared a couple things up or at least reviewed the situation for you. Any questions at all, please feel free to comment and we'll continue this conversation another time. Once again, I want to thank you very much for tuning in to MLETI.com and watching the training videos. Be sure to subscribe, like the page, and share amongst your law enforcement friends. We'll see you next time. Be safe.